Now, over the past several months, we've been covering the crisis in Oregon's public defense system. Right now, around 4,000 criminal defendants are without representation. Many of those cases are on hold, with defendants back out in our communities because there are no public defenders available to take their cases. Right now, Oregon lawmakers are trying to sort through mountains of testimony in order to craft a few bills that could help solve the problem. And they're also frustrated because they feel like they've dumped money into public defense without seeing results. In 2023, they invested about $100 million into the state's public defense system, and the crisis has only gotten worse since then. But tonight we're circling back to where our reporting began on this issue, with the nonprofit public defense firms. Recently, a group called Public Defenders of Oregon, which represents the nonprofits, put out their solutions-based action plan for fixing both the unrepresented crisis and the larger range of problems affecting public defense. We spoke with Carl McPherson, Executive Director of Metropolitan Public Defenders, which operates in Washington and Multnomah counties, about what they're proposing.
I think the short-term goals really are to increase the number of public defenders. The full-time providers, which are nonprofits and consortia, which do the overwhelming majority of the work in the state, there just aren't enough of us. We are the most cost-efficient models, the full-time providers by far. And the nonprofits are the ones who are recruiting and bringing people in overwhelmingly to the state to be the new generation of public defenders. I think there should be support for manageable caseloads. I know that's a controversial topic and a lot of people have strong opinions about it. But when your data shows that through surveys of people who leave public defense, the number one reason they leave are high caseloads, then you need to engage in those conversations and try to create policies and procedures that help alleviate and reduce that level of attrition due to high caseloads.
Another proposal are bi-weekly meetings at the county level between state officials, prosecutors, and public defenders. It would be an opportunity for all parties to collaborate and work out some of the local level issues. That could be a big improvement in counties like Multnomah, where communication and cooperation seem to be, let's call it, lacking. A lot of the nonprofit proposals are for ways to cut down the time these criminal court cases take by making sure cases are either dismissed early if they can't move forward, or that the state's evidence is shared with them in a reasonable time if the case can move forward. Public defenders might actually have some crossover here with prosecutors because both sides have argued for very different reasons that judges should have more authority to move things along. Something like that may require the legislature to step in. There's more to this solutions plan that you can read about right now on our website, kgw.com. But we're not done with the nonprofit public defenders just yet. So far, we've mostly focused on Multnomah County. And hey, for good reason. It has the single biggest source of unrepresented defendants in Oregon. But another major crisis county, as the state calls it, is Marion County. And it might be a cautionary tale, showing that as bad as things are in Multnomah County, it can get a lot worse. Judges in Marion County recently decided that if a public defender says they have a full caseload and can't take any more cases, a judge can force them to take more cases anyway. And that's not the kind of judicial discretion that many of the nonprofit public defenders are advocating for. Shannon Wilson is the executive director of the firm Public Defender of Marion County. They've been trying to rebuild since the last time judges began doing these forced appointments back in 2023.
We had been doing weekly workload analysis and providing that information to the court for a while. And it was quite surprising when we learned that the court was not going to accept those representations from our office any longer, that the court was just going to say, that's not our problem. Our duty is to just put a attorney's name on this case, and we fulfilled our obligations. It was quite the event, you can imagine. There was a lot of anxiety and just a lot of disappointment in our office that the court was choosing to approach the situation like this. So because we have a duty to protect our clients, we had to voice our objection on the record, and we did so. And they would appoint us above our objection.
Now, Wilson says they tried to fight the forced appointments, taking one of the cases all the way to the Oregon Supreme Court. And even though they eventually succeeded in getting their criminal case against their client dismissed, because get this, the prosecution wasn't ready for trial, they never got a ruling on forced appointments. Public defenders of Marion County was already without a lot of experienced attorneys, but as you might imagine, having cases forced on them hollowed the firm out.
Within that first 11 months, we lost 13 attorneys, and we're relatively, I would say, small to mid-sized firm of about 20 case-carrying attorneys. And so it was about 60% of our attorney workforce left within an 11-month period. It completely destabilized our office.
But that wasn't the only staffing blow. In 2023, the state kickstarted its trial division, hiring public defenders to work as state employees. Now, those jobs offer higher pay and lower caseloads, and the nonprofits can't compete. So the Marion County firm lost 5 more attorneys to the state, whose office happened to be just upstairs from Wilson and the last few members of their team.
I feel like it is a miracle that our office is still in existence at all. Losing that many attorneys. We've lost 80% of our attorneys since the beginning of this contract.
For a while, the judges in Marion County halted forced appointments, and that did give Wilson some time to rebuild with brand new attorneys, most of them straight out of law school. But Wilson says more of those forced appointments are, quote, looming. The presiding judge told them she would try to notify them before it happens. Wilson expects it will be sometime this month. But when it comes to what the legislature and state officials can do to keep public defenders in the game, Wilson said that ethical caseloads are the key to attracting attorneys, keeping them, and ensuring that they're able to fight for their clients.
That means just really holding the line and saying, you get to practice law here, you get to be an attorney. You don't just have to show up, shuffle papers, and push someone through the system. And I know that there's legislation right now to be considered that would essentially remove national and regional best practice standards from public defense. So if the legislature does choose to do that, I think we're accepting the reality that there was evidence that showed a way out from this crisis. And it would send a message to the public defenders that we are aware of what the evidence shows. We're aware of what you are saying the issue is. We're aware of what the data says, and we're aware of what you actually need to do as an attorney, and we don't care. That would be devastating to send that message to public defenders, to send that message to Oregonians that the right to counsel, a constitutional right, is just something we're going to cut corners on.
Now, this public defender saga continues, and we're keeping an eye on anything the legislature might come up with. But we would love to hear your thoughts. Do you think judges should force cases on public defenders? Is there another solution that comes to mind? Let us know. Email the story at kgw.com or call and leave a voicemail 503-226-5090. Or as always, hit us up on social media.